Yes, I said cyber tort legislations are the tip of the spear in the warfare against cyber assailants. Let's go. Hi again. Welcome back to the channel. I'm still Anthony Brown, your very own cyber lawyer and digital advocate. Today we are analyzing EU laws and regulations as well as a few judicial decisions. So let's go. First is the boss dog of data privacy legal framework, the General Data Protection Regulation, GDPR. It's the European Union's law for protecting personal data. It came into force in 2018 and has changed how companies around the world handle people's information. One of the most striking things about the GDPR is that it doesn't just apply to businesses inside the EU. If a company outside Europe, say in Nigeria, offers goods or services to EU residents or tracks what they do online, it must follow the GDPR rules too. That's called extraterritorial reach, and it means the law travels with the people it protects. The consequences for breaking those rules, well, they are serious. Financially, they can be up to 20 million euros or 4% of their global annual revenue, whichever is higher. These fines are for big violations like ignoring people's rights or failing to keep their data safe. The GDPR also gives individuals strong control over their personal data. Their rights include access to know what data is being collected and why, correction to fix wrong or incomplete information, erasure, also called the right to be forgotten, lets people ask for their data to be deleted under certain conditions. Portability, to move their data from one service to another. Objection, to stop their data from being used for ads or profiling. And restriction, to limit how their data is used in specific situations. In short, the GDPR puts people in charge of their own data and holds companies accountable no matter where they are in the world. We have the e-commerce directive 2031 EC. It's the European Union's rule book for how online services like internet providers, hosting platforms, and social media sites should handle user content. It's especially focused on intermediary liability, which means when should a platform be held responsible for what users post? The directive gives these platforms safe harbor protections, meaning they are not automatically liable for user content as long as they follow certain rules. On Article 12, mere conduits, it says that if a platform is just passing data along, like an internet provider, it's not responsible for the content as long as it doesn't tamper with the content. Article 13 on caching protects platforms that temporarily store data to make things run faster. They are safe as long as they don't change the contents and remove it quickly if it's illegal. Article 14 on hosting applies to platforms like Facebook or YouTube. They're not liable for what users post unless they know the content is illegal and they fail to act quickly to take it down once they are told. Article 15 says governments can't force platforms to monitor everything users do or post. That would be like asking them to constantly spy on everyone, which would hurt free speech and innovation. The directive strikes a balance. Platforms aren't punished just for hosting user content, but they do have the duty to act when something illegal is flagged. It's about responsible moderation, not constant surveillance. Thirdly, there's the Digital Services Act, the DSA. It's European Union's bold move to make the internet safer and more transparent. It was passed in 2022. It sets strict rules for online platforms, especially the big ones like Facebook, TikTok, Google, that have over 45 million users in the EU. These major platforms called VLOPs, very large online platforms, and VLOS, very large online search engines, have extra responsibilities. They must look out for serious risks like fake news, hate speech, and threats to democracy. and take smart steps to reduce those risks, like improving content moderation, tweaking algorithms, or redesigning their interfaces to discourage harmful behavior. The law also demands more transparency. For instance, these platforms must explain how their recommendation systems work, let users opt out of personalized suggestions based on profiling, and provide easy to read summaries of their terms and conditions in every EU language, including how their algorithms affect what people see and how content earns money. If a platform is based outside the EU but serves EU users, it must appoint a legal representative within the EU, respond quickly to government orders to take down illegal content or share user data, and most importantly, cooperate with regulators by sharing internal data for research and oversight. In short, the DSA is about accountability. It tells platforms, if you're big enough to shape public opinion, surely you're big enough to follow the rules. In the case of Times Newspapers Limited against United Kingdom 2018, the European Union Court of Human Rights took a close look at how freedom of expression works in the digital age, especially when it comes to online defamation. The court focused on Article 10 of the European Convention on Human Rights, which protects the right to hold opinions, share and receive information and ideas, to do so freely without interference from the government, and across all forms of communication, whether spoken, written, broadcast, digital, and artistic. But Article 10 isn't unlimited. It doesn't guarantee a general right to access all information, and it allows restrictions when necessary. For example, to protect national security or someone's reputation and rights. This balance is important. It means that while people have the right to speak and share online, they don't have the right to harm others with false or damaging content. These laws require platforms to remove harmful content like defamation, but also protect users' rights to express themselves and access lawful information. The message is clear. Freedom of expression matters, but so does protecting people from online harm. Stay tuned for more. Please like, share, subscribe. Please leave a comment and let's continue the legal discourse on the digital warfare that me and you are heavily a part of, whether anybody wants to believe it or not. It's your short play. Thank you.